Good morning, distinguished experts, participants, and honored guests. As we're about to begin our final conference day in Yerevan, I want to extend my deepest gratitude to each and every one of you for your contribution, professional cooperation, and valuable insight. These past 2 days have truly been remarkable and very educational for most, for myself for sure, if not for all of us. It has been a great pleasure to welcome back some of our old friends, as well as to establish new and hopefully long-lasting professional relationships. Your participation is a powerful statement of our shared commitment to advancing justice and providing the much-needed lifeboats and beacons of light to so many that are lost in the vast ocean of the international law, like it was referenced by Mr. Philippe La Rochelle yesterday. So big thanks to you all, and best of luck today. And now, without further ado, it is my honor and privilege to introduce our next keynote speaker, Dr. David Donat-Cattin. He's an adjunct associate professor of international law, climate change, and human rights at NYU Center for Global Affairs. Additionally, he is a research fellow of the Center for International Law Research and Policy of Florence, Italy, as well as a senior fellow of Montreal Institute of Genocide and Human Rights Studies at Concordia University, Montreal, Canada. He's both a member of Advisory Council at the International Center for Multi-Generational Legacies of Trauma, New York, and a member of Council of Advisors at the Global Institute for the Prevention of Aggression, New York. Over the last 3 decades, Dr. Donat-Cattin has conducted innovative research and published on pivotal matters of international law such as victims' rights, crimes against humanity, applicable law before the International Criminal Court and jurisdictional issues, the Rwandan genocide, the crime of aggression in and against Ukraine, and much, much more. Some of his prior works around the Armenian issue include his active promotion of Armenia's ratification of the Rome Statute of the ICC as early as in February of 2003, as well as May 2006, targeting key Armenian lawmakers in his capacity as the Secretary General of the Parliamentarians for Global Action, a role in which Dr. Cattin served in for 3 consecutive terms. As a legal scholar, he has also published articles relating to matters that have remained very relevant and important for the Armenian community around the world, such as his article in a collective volume for the 100th anniversary of the Armenian genocide, in which he has made the legal case for the right of descendants of victims to obtain reparations. While the list goes on, and the vast number of truly remarkable accomplishments of our next keynote speaker can hardly be all listed here within the time allotted to me today, I should note that Dr. Donat-Cattin's efforts have contributed to the ratification process of some 78 out of the 124 states parties to the Rome Statute, 79 if we count Armenia, which joined within the last year. So, without further ado, please join me in welcoming Dr. David Donat-Cattin at the podium. Thank you very much.
Thank you very much, Cor, and I'm so honored to be here. Finally, I am very happy to pronounce the acronyms TJ. I have always had a problem with TJ because of transitional justice. To me, justice is permanent, not transitional. It contributes to transitions towards democracy, the rule of law, peace, maybe in Azerbaijan, a green economy one day, and peaceful relations with friendly nations and neighboring countries. But yes, this Center for Truth and Justice is what we need. And you should continue your work, you, Judge Gassia, and this fantastic team that you have. This is one of the best conferences I've ever been. And certainly your organizing committee is the most hospitable and gentle and kind team I ever met. I will focus only on 2 things because I think this conference already covered too much and I have not so much to offer more. The first will be about the role of Armenia as a state party, and here I'm watching my friend born on August 5, 1989. Dr. Petrosyan. So since you mentioned many date of births, I think it's worth mentioning yours. I think without you, not without me, without him, Armenia would have not been a state party. So, yes. Let's say the things as they are. And let me tell you why I failed 20 years ago. And there is one single word, well, two words, because we are lawyers, so we give the legal name. The reason why I failed, Russian Federation. The meeting I organized was in the Russian State Duma, the first ever organized NGO-sponsored meeting in the Duma, organized by Parliamentarians for Global Action at a time in which no united Russia party existed in the Duma and real opposition existed. And by the way, President Putin supported the domestic implementation of the Rome Statute in Russia and sent his legal advisor Paleyev to present on that, on the same date of Afghanistan deposit of the instrument of ratification to the UN. So I got a question from the office of the President of the Russian Federation. Do you know why, Dr. Donat Cattin, Afghanistan today ratified the Rome Statute? I had an answer, others didn't, but it was an interesting debate. And I think, unfortunately, Armenian parliamentarians relied too much, as many leaders at that time, on the special relationship or alliance with Russia. And in the end, in 2006, when we organized a meeting in Salzburg under the Austrian presidency of the European Union, where the president of the Foreign Relations Committee of the Armenian Parliament was one of the main speakers, and I invited him to be there. And of course, he said in public, of course, Armenia will ratify the Rome Statute, because the speeches were always perfect. We will do it. The Constitutional Court said we have to change the Constitution, but we will fix it because we are victims of genocide and we have to do it. It's a legacy that we cannot betray. The reality was that there was another political agenda ongoing, but unfortunately it didn't work well for Armenia, for the people of Arsat, and for the situation we are witnessing today, where that very strategic ally is now the protagonist of the worst war of annexation and aggression that we have seen following World War II. So here we go. I have a next task for the state party of Armenia. Armenia has a lot of things to be done in the Assembly of State Parties, not interested so much in the rest. Let's focus on the ASP, a state party. The Assembly of State Parties, these missing arms and legs of the big giant head of the institution, to cite again Antonio Cassese. Let's make it work. And the first to be done is to legislate and innovate, because the way the crime of aggression has been included in the Rome Statute does not allow the court to prosecute Vladimir Putin for the worst crime committed today in Ukraine, which is the crime of aggression. Without it, no other crime would be committed. And he's benefiting from a present we gave him, the state parties, in Kampala, with Article 15 bis, paragraphs 4 and 5. And there is a core group of state parties, led by Germany, that wants to amend the amendments. This will be on the table of the next ASP. There will be a meeting on the 17th of July next year, and probably by the end of the year there will be a decision to be made. I'm talking about 2025. Armenia, with its vote, can be part of this legislative change. And in parallel, I would argue it would be very wise for Armenia to ratify the Kampala amendments, so that as a state party to the amendments can have this enter into force and capture those who would decide one day, if they, and so a layer of deterrence, if they would decide to commit a war of aggression, an attack, an armed attack against the sovereign soil of these nations from neighboring countries or from other regions of the world. The Assembly of State Parties should be doing more on non-cooperation, on compliance, on ensuring that the Rome Statute is respected, and I trust that Armenia will be a very strong partner of the other state parties to change, because we need an agenda for change at the ASP. Somebody has said that the International Criminal Court is costly. The International Criminal Court costs as much as one helicopter and one F-16. All right? The OTP budget is less than the budget to buy an helicopter from Boeing, all right? This is the budget of the ICC, 150 million euro per year, more or less. It's ridiculous. That's why the court doesn't have enough judges, doesn't make enough work. Of course, then maybe there is also a layer of efficiency and effectiveness that needs to be worked on. Not everyone performs the same way. Not all the judges know the law the same way. There is room for improvement, as in every entity and institution. So Armenia can. You have so many brilliant lawyers. And let me move to the case. The second part of the keynote speech is about the case. What I would call the deportation and persecution case. Because when we mention the Myanmar precedent, it's not only about deportation as a crime against humanity, which has a transboundary realm, and that's why on the basis of Bangladesh territorial jurisdiction, the court can exercise jurisdiction over the deportation of the Rohingyas, all right? On the basis, which happened on the basis of genocidal policies. But it's not the crime of genocide there that is being actioned upon. And I would argue this is the same case for the Arsat people, the 120,000 who were forced to leave to survive, all right? Once you are forced to leave to survive, it means that you are a victim of the crime against humanity of persecution, which goes hand in hand with deportation. So it's not only deportation, it's also persecution. And persecution was a main element of the Nuremberg judgment. Probably the second biggest crime after the, of course, the crimes against the peace, now called crime of aggression, which out of the 12 volumes of the Nuremberg judgment, about 10 of them are about aggression. 2 of them are about the other war crimes and crimes against humanity, and persecution is squarely there from day one to the end of the trial. And it's of course persecution on a ground that can be, listed as close as possible to genocide. It's some sort of a genocidal conduct without specific intent to destroy. You need to prove that. Am I right? So, and the fact that you were allowed to survive and you had a route to escape could be used as an exculpatory evidence to say it was not a genocide. We don't need that because persecution doesn't invoke that type of defense. So I would say that the case must be made, the persecution continued beyond the borders. There are even the office of the prosecutor, but the court as a whole is not insensitive to cyber attacks and other elements that can have a cross-border dimension. It can be ongoing today, can repeat tomorrow, and I think this would be a very solid case. Now, who should bring the case? Arguments have been made about referrals or self-referrals. I would disagree on that. This was really the policy of the first prosecutor, to generate self-referrals. Remember the old days of DRC, Uganda, and so on. We don't need that. It's not a problem for the pre-trial chamber to work a little bit more than they do. They don't have too much work. There are not too many persons tried at the court at the moment. And I do believe that instead what counts most is the legal entity that could be recognized as victim, in addition to, under Rule 85, in addition to all those of you individuals who were forced to leave, because you are all individual victims of the crimes of deportation and persecution as crimes against humanity under the Rome Statute. And I'm referring not only to the Center for Truth and Justice, which is, of course, an entity that should be there, continue to be there, because you are the driving force. No mistake about it. But I think the Arsat survivors could put together all of them, all together under one umbrella to make things simpler, because that's what, whether we like it or not, that's what they like in the Hague, to make it as simple as possible. And have an association of the victims of Arsat that goes together, all together, before the prosecutor and the other organs of the court, with a submission again, saying, make this case proprio motu. It's one case, one neat and clean case. This is all the evidence, and it's collected by us, with us. It's a fantastic model, the one that you have inaugurated here. It's a peer-reviewed gathering of witnesses by the survivors with other survivors. You don't have external international NGO flying in and helping you out. You don't need translators. You don't need there is no intermediary here. It's your people able to gather, collect and preserve the evidence and maintain the chain of evidence. So this association of victims should also be recognized as a legal entity with a local standing under Article 85, because also it preserves the culture, the religion, the tradition. So if you see there, the court may also accept as victim a legal entity in addition to the individual. Ultimately, a lot has been said about modalities and forms of reparations here. Maybe one of them has not been mentioned, and I think it's probably the most relevant one in the Armenian case, and it's what we call guarantees of non-repetition. Joining the Rome Statute in and of itself is part of that toolbox of guarantees of non-repetition. The message should be sent loud and clear to the Azerbaijani side and all the other sides, because you never know who can be the threat in the future, that Armenia abides to the rule of law. It's a peace-loving nation that abides to the rule of law. And a guarantee of non-repetition is constituted of many, many elements, including memorialization, including rewriting of the history books, including a culture of regional integration, because ultimately, only through those non-violent means, we could achieve the right, the fulfillment of the right to return in the properties, in the homes, in the villages, in the cities, in the localities where the people were forced to live. Everybody have been saying this. It takes time. It takes generations, possibly. But you should never give up. The Arsat cause should never be left behind by any of you. I still have 5 minutes. Oh my God, I'm being too fast then. So the next step would be to work with neighboring countries. Of course, in the region, Georgia is already a state party to the Rome Statute. So that's the first place where to start. But you know, things should go hand in hand. And now, for example, when I think about, maybe it's another region of the world, so you know, don't make confusion here. I don't want to mix apples with pears, but when the first country that emerged out of the Soviet Union joined the Rome Statute, I'm referring to the Republic of Tajikistan, if you study the way they decided to ratify the Rome Statute, it doesn't mean that it solved all their human rights problems, far from saying that. It's not, you know, joining the Rome Statute is not a panacea to clean your human rights record or to improve your legal system and so on. It should, but it not always happens. It needs a lot of follow-up action in place domestically. Well, why did Tajikistan ratify the Rome Statute? Because in the framework of a UN-brokered peace agreement, within the package deal, there was ratification of the Rome Statute as a guarantee of never again. This should never happen again. These crimes, these atrocities against civilians, this failure to give access to justice, never again. And as a guarantee of non-repetition, somebody in the UN legal office or somewhere else suggested them, and you should join the Rome Statute. In my own small capacity at that time, we were pushing for the UN to embrace this type of policy. Out of the failures of the Lomé peace agreement that brought Foday Sanko of the RUF as the vice president of Sierra Leone in March 1998 to then, you know, restart the war, and which was then resolved only in 1999, and with the creation of the special tribunal with the indictment against Charles Taylor and Foday Sanko himself. So I think this is also what should be included in these, what I've understood is going on in a peace or peace talks between Azerbaijan and Armenia. On the first day I've understood things are going on. Yesterday I was shocked to see once again the red dots in the Armenian territory, which are the places where Azeri forces are present with the consent of the territorial state, so it's not crime of aggression. So your foreign ministry official could cool down and be relaxed about it. The definition of the crime of aggression in that article is as an extremely high threshold. Not every violation of the prohibition of under Article 2.4 of the UN Charter, the use of force, is crime of aggression under that definition. You have a very high threshold that eliminates the possibility that any gray zones get criminalized. To the satisfaction of many critical scholars, or to the, unhappiness of many other critical scholars, especially around the world. So, as every diplomatic compromise, what we have in international treaties does not satisfy all. But I think that if there is a resolution to be given to this status quo, it should include the rule of law. It has been said that there is no durable peace without durable or sustainable justice. Both of them, they have to be durable and sustainable. And I would argue that within that agreement, maybe Armenia should try to include a language on Azerbaijan joining the Rome Statute, as Tajikistan did. Maybe this will fail, surely this will fail, but the fallback could be that, under that framework, there is the assumption that if the agreement will be broken, there will be a judge in the Hague. So I think we should make sure that we use the law to the advantage of victims' rights, because at the end of the day, they are the ones who suffer. When we speak about crimes against humanity, shocks the consciousness of humanity, threatens the international community as a whole. We may quote Barcelona Traction and the Youth Coggins. We are wonderful as lawyers to make these lofty speeches. At the end of the day, who suffered in the field? Those individuals who were present here and the 120,000 who had to flee. So first and foremost, the justice is due to them. But if the government officials, those who blocked the ratification for 20 years, they could have joined in 2003, as Afghanistan did. They could have joined in 2004, as Georgia did. They could have joined in 2006 or later, but they waited until almost the end of the armed conflict in Nagorno-Karabakh, am I correct? And it didn't go right for Armenia. And this is very sad. And I really hope that Ukraine will deposit the instrument of ratification before the end of the war with Russia, the ongoing phase of the war, because it didn't happen yet. Ukraine did not ratify yet, right? Because somebody cited the fact that Ukraine will be the 125th. Not yet. Until they deposit, it's not a valid ratification. It's a parliamentary authorization to President Zelensky to ratify. So in the meantime, I really hope that out of this conference, Center for Truth and Justice and all the Armenian participants could really come up with one voice to ask the government to ratify the Kampala amendments, participate actively in the amendments of the amendments to ensure that everybody is treated equally before the law when they perpetrate the crime of aggression, and move forward with the peace talks in a way that conforms the imperatives of peace with the imperatives of justice. Thank you very much.
Thank you very much. I'm not sure we had a Q&A for this one, but I got some questions, and maybe I'll combine them to one, and I guess I'll allow another question if you will grace us. So there are several questions, and I'm just going to try to combine them and make it. This is relating to the Victims Association that you mentioned, the idea of the Victims Association being probably the better path. And the question is about the best way of maybe forming it. The person asking the question is wondering if it could be led by prior maybe leaders of Artsakh. There's also a question about this, if this group can also make any kind of involve, I guess, the Russian peacekeeping troops who were there, who did not necessarily participate in the killings, but facilitated the eviction. And last but not least, if there was a real or any, if there's a real legal path or possible path to Artsakh individuals returning back home, if it's something doable even.
Many questions. Maybe as an introduction to it. A lot has been said in this conference on the principle of complementarity. And the principle of complementarity is one of the three pillars of the Rome Statute system, alongside the obligation to cooperate and the principle of legality, in broad terms. No? Well, we have situations in which states at the highest judicial level, and speaking about the jurisprudence of the Cour de Cassation of the Central African Republic, came out with very realistic statements on what the principle of complementarity is. And I deliberately mean here the principle of complementarity in terms of its black letter, not what is being assumed to be in, positive notions. Positive complementarity has been discussed for many years, or policy papers and so on. And the idea is that impunity is so prevailing that if the ICC wants to open a case, it's welcome and should take precedence. That's the jurisprudence of the CAR, Central African Republic. And we will do our own job at home by creating a special criminal chamber to end impunity as much as we can domestically with international cooperation. Of course, we are talking about one of the poorest nations of the world, not to be compared with Armenia. Armenia is in a much better position. But this is to say that when you have especially in the Armenian situation is also different, because we are talking about an international armed conflict, not a non-international armed conflict. All right? And in international armed conflict, international justice is particularly relevant and important, because you want to make sure that justice is accepted by all sides, And don't make an assumption that the majority of the Azeri people partake the nationalistic ideology of their president, all right? Don't make that assumption. Remember that in history, we have to learn the lessons of history. I'm Italian, so I can tell you, we invented the worst thing that we have on earth today in terms of ideology, which is fascism. Adolf Hitler was inspired by Benito Mussolini and learned the lesson. And the day before fascism was declared ended as a regime, on the 7th of September 1943, 90% of Italians declared themselves fascists. The day after, 90% of Italians were anti-fascists, suddenly, all right? So don't make wrong assumptions. Peace is made with peoples, and Azeris are people who want peace, want to have quite an happy life like you want to, like we've seen yesterday at the winery, correct? So we need to use the law to bring about that goal of peace, harmony, cooperation, and so on, restore the legality in the relation among nations. And complementarity is there to assist states to make sure that justice is not only done, but is seen to be done in an impartial manner. And can the Azeri people, even those in good faith, most of them supporting Iliyev apparently, accept a judgment rendered by a court in Yerevan? So that's why we have international justice. Complementarity is not there as, some sort of burden-sharing principle in an abstract situation. It's a burden-sharing principle not in an ivory tower. That country, Guinea, complementarity. It was totally different. It was not an international conflict. It worked in Guinea. Certainly it worked. The argument for years was it should work for Ukraine too. It didn't work. things got much worse. We waited and lost a lot of years. What about Afghanistan? Complementarity in Afghanistan? Are we joking? The Taliban are back. Wake up. Why did the court didn't do nothing after the President Karzai ratified the Rome Statute? On the same day, I was with the Armenian parliamentarians in the Russian State Duma to speak about CIS states ratifying the Rome Statute. By the way, Georgia did it a few weeks after, a few months after. So the conference worked. All right? So we made so many mistakes. Are we learning from them? So what I'm saying here is that we need a case on the ARSA situation. And we need to be forceful and not to allow complementarity to be used to postpone, postpone, and postpone, and postpone. Stop. Do your job. Apply the Rome Statute. That's what I'm saying to my friend and colleague Karim Khan when I will meet him. I will tell him, you are doing a fantastic job. Go on and take this case too, because it's so good, it's so neat and clear, and who's running it? The victims themselves. And my view, the best chairperson of this association of the victims is your legal advisor, who spoke the other day. She's perfect. Shouldn't be a politician leading this association. Never. Don't put a politician. I work with politicians for too many years. They are necessary actors when you need state parties to join the Rome Statute, to legislate, change the laws. They are legislators. They join the executive. Don't make them mixed up with the courtroom work. That's the realm of the judiciary, separation of powers. Put a lawyer in charge. Put a lawyer in charge. Let's learn the lesson from our great masters. Benjamin Ferenc was a lawyer, and he was the best in championing the cause of international justice. Am I right? So let's give the leadership position to somebody who is not a political figure, who will not run for office in the future. And this should be an association, an NGO under Armenian law. That's what it is. We don't need any transnational or international dimension. The most localized it is, the best it is. You can even try to open an Azeri branch. You will fail, but you can, in the courtroom, you can produce the fact that you are not politically driven. In fact, you try to open an Azeri branch during COP. The second day of COP, you go there and you register, you see the reaction. And if they say no, you make a press conference. And you invite the lawyer of Azerbaijan to be in the panel, Mr. Rodney Dixon, King's Counsel. So, there are many things. So you should have this strategy to put the prosecutor on a wall in a nicely way. He's a wonderful human being. He's doing an extraordinary job. We are living in a new era. Today, year 2024, the head of state of a permanent member of the Security Council who can launch a nuclear war is indicted for war crimes and crimes against humanity. It's a new era. Of course, the prosecutor also requested an indictment, an arrest warrant, for the president of one of the closest military and political allies of the greatest superpower, the United States, the Prime Minister of Israel. We are living in a new era when people say, including presidential candidates, we have to live in a rules-based order. Wonderful. That's what we have. We have a rules-based order. And those who do not abide to it, they are violating the law. It's not that the law does not exist anymore. It's just that there is a prevalence of violations. It happened many times. I work in New York City. It happened in the Bronx in the 1970s. There was a prevalence of the violation of the law. Am I right? You couldn't easily walk in the Bronx. Today you can. So I think we need to restore the rule of law. I come from Italy. The largest contributor to the economy of our largest island in the Mediterranean, Sicily, until the 1980s was the mafia. They were giving hundreds of thousands of jobs to people. Well, we cannot do anything about it. Now the mafia is reducing Sicily to the third most dangerous criminal organization in Italy. They are very much downscaled. They're not as dangerous as the Ndrangheta from Calabria, which is the real threat now. So this is what it is. things change if you apply the law. Was there war, civil war in Sicily when, when the head of the mafia was arrested? No, it was not. It's not true that if you fight crime, you bring instability and war in relations among individuals. You simply change, you adapt. You live with it. So I really believe that the best vehicle for a strong case is to debunk myths like the one of complementarity. Complementarity has been abused by the offices of the prosecutor over the years for the purpose of not doing their job, not doing cases. First of them, the ones that President Karzai asked the court to do on the leaders of the Taliban and the leaders of the Northern Alliance, who had put in a train hundreds of young Talibanis to make them die by starvation. Maybe the temporal jurisdiction of the court didn't apply at that time. But maybe we would be in a better war without those leaders that were in charge, by the way, of the Afghani government when they left Kabul, and then on the 15th of August 2021, the Taliban took over. So we need to learn the lessons of the history, and Arsat case can help to change the path. So let's use it, and I think it can be, and again, it's a manageable case. It's not such a, it's very clear what happened. It's very well documented. It has been protected. The chain of evidence is very protected. There is no foreign, there is not Human Rights Watch or Amnesty International here colonizing Armenia, all right? Am I right? I love them, they're my friends, but they hear crazy stuff around the world. And I really tell you that if the court doesn't do its job, it's the court that is racist towards Armenians, towards victims in Sudan, towards victims of crimes against humanity, wherever they are, whatever the color of the skin of the victims. All right, because I've heard things reported here. The court must apply the law as it is, and of course there is discretion, but the discretion of the prosecutor is not unfettered. Because under Article 8, for example, there is a clear distinction between random war crimes and large-scale and systematic war crimes, and that's where the prosecutor in particular should look at. So we have norms in the statute directing the discretion of the prosecutor. There is broad discretion, but it's limited. And I wanted also to say another thing, but go ahead with the final question.
Actually, I think we're past our time, but it's so engaging. Like we're just all paying attention. Hopefully, nobody will get angry with us. But so, if you want to finish your thought, maybe.
Okay.
Thank you very much.
Thank you very much. So I think there is a path towards advocating forcefully and clearly for the opening of a case. My final point is on the crime of genocide. Right? Genocide is punished under the Rome Statute exactly with the same penalties as crimes against humanity, and also war crimes. But the war crimes belong to another category. You can opt for war crimes for 7 years, even though it shouldn't happen. Under Article 33, a manifestly unlawful order, by definition, is when the order pertains to the commission of genocide and crimes against humanity. But for war crimes, there is something to be proven in your defense, potentially. So war crimes, they have a little bit of a diminished dimension, even though the penalty also for war crimes is the same, so the counter-argument can be made. But crimes against humanity and genocide, they belong to one and only category. So it's not a diminution if genocide is not charged. I don't like acronyms. Genocide is genocide. There is no G. It's genocide. There is a convention for the prevention and punishment of genocide, which attaches to it state responsibility and a number of duties. We hope next year to have, in 2 years, to have a convention for the prevention and punishment of crimes against humanity that will have almost the same guarantees and obligation of prevention, and Armenia should be part, and I think Armenia is one of the co-sponsors already of that resolution at the UN. Russia is voting against, it's trying to block it. So again, the main enemy there has one name, and I already gave it to you, and we should move forward with that. So educate your public. There is no need to have genocide in the game. also because the transnational or transborder dimension of genocide can be questioned and there is no precedent, whereby for deportation and persecution, not only deportation, we have the precedent and we should maximize on it. And finally, those found guilty beyond reasonable doubt, they are presumed innocent today, they could be going up for the highest penalty, the same as applicable for genocide, which is life imprisonment. So I think that's another element of the campaign that I would like to see there, led by lawyers, educating the general public about the importance of crimes.
Well, thank you very, very much, Dr. Cattin. And sure, go ahead.
But it's not about the punishment. It's about the crime. And there's a specific intent to genocide, which is to destroy the group. It's not the same as crimes against humanity. And we see clearly in the case of Mnatsakanyan. So saying that we should forget about genocide, I have to fully, 100% disagree. I know the difficulties of the jurisdiction, but there are other venues outside the ICC that could be used. And people, victims, should not forget that they are victims of genocide, not crimes against humanity, or maybe at the same time, a genocide for sure.
Thank you. Maybe a brief remark. Thank you.
I think, I mean, of course, all the descendants of the 1915 genocide are still victims of genocide. That's an argument that you also made, and I understand that it's very important. I respect what you say. If I look at the jurisprudence on genocide as of today, I think the burden of proof for a case of genocide in this situation is quite high. I'm not saying that it cannot be proven. I'm not saying that. And you're right. Under other jurisdiction, it can work. I would really urge caution vis-à-vis using the ICC as the venue where to bring that charge. So I'm not saying here I'm talking about moving forward from a situation. Let's be honest today. Today the prosecutor is going to do nothing on Armenia because of Ukraine and Palestine, or budget constraint or whatever. So we need to move out of that blockade, correct? And there is one person who can decide to move out of the blockade. That's the way it works, because it's an individual organ of the Rome Statute system. The prosecutor is an individual organ. And we are lucky, so we know where to target our efforts. It's not like at the UN or where you have an under-90 state. So it's an easier job. And I think we have a very forceful case. And we have to have a very clean and neat strategy, not ambivalent. And I think, of course, I think a fortiori, your argument can be put also in illegal briefs. I'm not saying no. I'm not saying no. So I don't want us to be, we are not, I don't agree with you, but it doesn't matter. I think you have very solid arguments. One can disagree, but in a respectful way. Say, what? Yes.
Ladies and gentlemen. Ladies and gentlemen.
There is a chairman.
Thank you all for being so engaged. This is very, very important. This is why we come here, but maybe we can talk to each other at the halls. Everybody's very friendly, and this is how we will find, best resolution. Dr. Cattin, thank you so much. I don't mean to cut you short, but